The container did not arrive. That is the fact the Department of Justice placed at the center of a December 2025 announcement, and it is also, read carefully, the only fact the announcement is willing to defend. Operation Gatekeeper, the multi-defendant disruption of an alleged artificial intelligence chip smuggling network valued at a minimum of $160 million and routed toward mainland China and Hong Kong, was announced as the largest single disruption of its kind under the current export control regime. The charging documents that accompany that announcement tell two stories. The first is about a network. The second is about what the network's existence quietly concedes. The record establishes, in its plain language, the following: at least 8 defendants, multiple jurisdictions, a declared chip value of at least $160 million, alleged destinations in mainland China and Hong Kong, both subject to the most stringent tier of semiconductor export restrictions currently in force. The announcement does not describe a single exporter who located a willing buyer across a border. It describes what its own language calls a network, and the multi-defendant structure of the indictment substantiates that framing. Prosecutors charged a connected set of actors operating across institutional lines, not a sequence of isolated decisions. The word operation in the case name is not incidental. It signals that what was disrupted was infrastructure, not opportunism. The chips are described in the announcement as artificial intelligence chips. The public-facing language does not resolve exact model designations or specific performance thresholds, though the export control classifications invoked in the charges implicitly anchor the devices to the advanced accelerator category that the October 2023 rule updates, and their successors brought under the strictest controls. The charges do not leave the device category undefined, but they do leave it unspecified at the granularity a technologist would want. That is the first place the record says something by declining to say it precisely. What the record establishes, in sum, a professional infrastructure, 8 or more participants, at least $160 million in declared chip value, multiple jurisdictions, and a disruption announced as the largest of its kind. These are the facts the Department of Justice is prepared to defend in court. Everything outside these facts is either in the margins of the document or entirely absent from it. The announcement establishes the value of chips involved in this operation. It does not establish what share of total illegal artificial intelligence chip flow this disruption represents. The denominator, the estimated size of the full illicit market against which $160 million would be a meaningful fraction, does not appear anywhere in the record. The document is silent on whether this disruption represents a significant portion of an illicit market or a visible sliver of a much larger one. Prosecutors announce what they can charge, not what they estimate they have not yet found. But the silence itself carries information. The Department of Justice did not claim to have disrupted the majority of illegal chip flows. It did not claim to have found the primary channel, or the most sophisticated network, or the operation with the deepest reach. It claimed the largest single disruption under the current regime. Those are meaningfully different assertions, and the record makes only one of them. The record enumerates defendants and jurisdictions. It does not name the ultimate end users, the specific computing applications the chips were destined to serve, or the infrastructure that would have received them. The indictment is a record of a supply chain. It is not a record of a demand chain. This omission follows from evidentiary logic. Prosecutors charge the actors they can prove participated in the export violation, not the actors who placed the order in a jurisdiction beyond United States reach. The result is that the record, read alone, tells you about the pipe and nothing about what was intended to flow through it. Export control enforcement documents typically identify, where known, the foreign end user, the entity that was to receive the controlled technology. Operation Gatekeeper's public announcement does not name a specific end user entity in mainland China or Hong Kong. It names jurisdictions, not recipients. Whether that omission reflects a genuine gap in the evidentiary record, an ongoing investigation the Department of Justice is protecting, or a deliberate choice to limit the scope of the public charges, the document does not say. An absent end-user designation in an export control case is not a minor formatting choice. It is the most load-bearing silence in the record, because the end user is the entity whose capabilities the control regime exists to constrain. The announcement characterizes this as the largest single disruption under the current regime. It does not characterize it as the most sophisticated, the most technically capable, or the hardest to detect. A record about scale is not a record about detection difficulty. It is not a record about how long the network operated before it was found, or about what countermeasures the defendants employed. The charging documents establish that the network existed and that it was large. They do not establish that it was the only network of its kind, or that the investigative methods that found this one would find others structured differently. The record's silence on operational longevity is among the most conspicuous omissions in the announcement. How long these defendants are alleged to have operated before disruption, how many transactions occurred, and what the network's full throughput may have been across its active period, none of that is settled in the public-facing documents. Prior enforcement actions under the artificial intelligence chip export control regime were predominantly structured as single defendant or small group cases: an exporter, a freight forwarder, a middleman. Operation Gatekeeper's 8+ defendants and multi-jurisdictional structure represent something the charging language itself marks as categorically different. What the record does not say is when that infrastructure professionalized. The indictment charges the conduct it can prove. It does not date the emergence of organized smuggling as a distinct phenomenon from ad hoc violations. That question, when opportunism became architecture, is one the document opens and does not answer. The announced value, at least $160 million, is a declared value of chips involved in this operation. The record does not state whether this represents chips physically seized, chips charged in the indictment, or chips alleged to have moved through the network over its full operational life. Each of those denominators would produce a different meaning from the same headline number. The document does not resolve which one it is using. The figure is real, and it establishes a floor. It does not establish a full ledger, and the announcement does not claim that it does. A customs seizure records that a container did not reach its destination on that voyage. It does not record whether another container, on a different route, carrying the same cargo, cleared inspection the week before. Operation Gatekeeper's announcement is a record of one voyage, and the port log for the others is not in this document. The record does not establish what evidence remains sealed or under ongoing grand jury process. The charges described are allegations, and the document is careful to use that language even where the announcement's framing implies confidence. What the indictment will ultimately prove and what it will not is not yet in the record. The announcement does not establish independent estimates of the total illicit market. No third-party trade data, no customs service aggregate, no academic estimate of diversion rates appears in the Department of Justice document. The record cannot tell you whether $160 million represents a tenth of the problem or a hundredth of it. The document does not address the authorized supply side, which distributors, logistics intermediaries, or financial institutions, if any, process transactions that ultimately fed this network without detection. That question is entirely outside the record's scope. These silences, taken together, mean the record establishes one very specific thing: that a large organized network existed and was disrupted. They decline to establish the broader condition of which that network was a symptom. Read plainly, Operation Gatekeeper's charging documents record that organized, professionalized infrastructure for circumventing artificial intelligence. Chip export controls reached a scale of at least $160 million across at least 8 defendants in at least 2 restricted jurisdictions, and that this is the largest such disruption the current regime has announced. The record does not say the regime is failing. It does not say the regime is succeeding. It says a network of this scale existed long enough to reach this size before it was found, and that the document memorializing its disruption is silent on everything that came before and everything that remains outside its 4 corners. The document that announces the largest chip smuggling network disruption under the current export control regime does not once state that the controls prevented the chips from being useful to their intended recipients. It records an interdiction. It does not record a denial. Those are not the same thing, and the charging language is careful never to conflate them. The largest disruption in the record is still only as large as what the record contains. The next document worth reading closely may be the Bureau of Industry and Security's subsequent rule amendments. because the specific control classifications invoked in the Gatekeeper indictment will tell you exactly which chip capabilities the United States government has decided are worth criminalizing the movement of, and which capabilities the rules have quietly left unnamed. If you want to read that document when it appears, subscribe and turn on notifications, because the amendments, like this indictment, will say less than they mean